This video will be discussing important MCQs for CLAT on criminal law. These questions are very important, not even to the aspirants of CLAT, but even for the LLB students. Let's start. A criminal offense is committed only when an act which is forbidden by law is done voluntarily. Ordinarily, a crime is not committed if the mind of the person committing the act is innocent. Both 1 and 2 are incorrect. Both 1 and 2 are correct. Only 1 is correct. Only 2 is correct. A criminal offense is committed only when an act which is forbidden by law is done voluntarily. It is correct. A crime is not committed if the mind of the person committing the act is innocent. It is also correct. So both 1 and 2 are correct. Mind of the person committing the act is innocent, that is actus mens rea, it is illegal. Guilty mind is not present in the action, therefore the crime is not to be said as committed intentionally. Which section of the Indian Penal Code 1860 defines the term voluntarily? Section 37, 2, 38 or 39. The term voluntarily is defined under section 39 of the IPC. Voluntarily is said when a person is said to cause an effect of voluntary when he causes it by means of intention to cause it. If there is an intention to cause that, then it is defined as done voluntarily. So it is defined in the IPC under section 39. The word dash has not been defined anywhere in the IPC, but its essence is reflected in almost all the provisions of the IPC. Knowingly, voluntarily, mens rea, fraudulently. It is mens rea. Mens rea means a guilty mind. In every criminal proceeding, the law starts off with the contention of mens rea, presumption in favor of innocence of the accused, presumption that the crime is committed by the accused, presumption that the sufferer is free from any guilt. In every criminal proceeding, the law starts off with the presumption in favor of the innocence of the accused. B is the correct answer. From the following, identify the article of the Constitution of India which stipulates that the President of India is exempt from the operation of criminal law. Article 360, 361, 359 or 358. This exemption is given under Article 361. Article 360 is talking about financial emergency. These all are emergency provisions to national emergency, financial emergency are provided in all these sections 358 to 360. Exemption to President is provided under Article 361 from the operation of criminal law. The maxim ignorantia facit doth excusat. Ignorantia juris non excusat means ignorance of fact excuses, ignorance of law does not excuse. Ignorantia facit doth excusat. Ignorance of fact, facit, fact, excuses. Ignorance of law does not. Ignorantia juris, juris means law, does not excuse. That is to say, ignorance of a fact is an excuse, but ignorance of law is not an excuse. So A is the correct answer. One of the essential conditions for an accused to be protected under the mistake of law and bona fide acts is good faith, element of ignorance, non-committing nature to the act, or negligence. It should be good faith. Essential conditions for an accused to be protected under the mistake of law and bona fide act is good faith. Under Article 52 of the Indian Penal Code. Generally, under the IPC, nothing is considered to be an offense if it is done by a child under how many years of age? Ready? 7 years. Under Article 82 and 83 of the IPC, which confers immunity from criminal liability to children, there is a legal term doli in capex, that is, a child below the age of 7 years. Any action committed by this child is not an guilt. That is to say, a baby below the age of 7 years could not commit any crime. Doli in capex. The Juvenile Justice Act 2000 defines a juvenile to be a child who has not completed how many years of age? 18, 21, 16 for boys and 18 for girls, 18 for boys and 21 for girls. It is uniformly 18 years for girl and boys. Homicide can never be lawful. This statement is true, false, partly true, or none of the above. Homicide can be lawful only in the case if it is done to prevent a greater harm to innocent people. Therefore, homicide can never be lawful is false. Which of the following maxim means let the punishment be proportional to the crime? It is culpa pena per esto. That is, let the punishment proportion to the crime. Culpa pena per esto. The Law Commission's famed, which report reiterated that the need to treat juveniles with care and not punish them. 181st, 42nd, 180th or 179th. It is the 42nd report of the Law Commission that reiterated that the need to treat juveniles with care and not to punish them. Guidelines for protection of witnesses were issued in the Nilam Katara case, Shivani Bhatnagar case, Ketan Tirotkar case, Noida double murder case. Guidelines for protection of witnesses was issued in Nilam Katara case. Insanity or mental abnormality is one of the general exceptions to criminal liability recognized by the IPC. The principle is based on the principles of mens rea. Only one is correct, only two is correct, both 1 and 2 are correct, both 1 and 2 are incorrect. This insanity or mental abnormality is one of the general exceptions to criminal liability. It is correct. This principle is based on the principle of mens rea. This is also correct. Both 1 and 2 are correct. In legal terms, a recidivist is A. The first time criminal, believer, atheist, and habitual criminal. It is a habitual criminal. The maxim voluntary non-fit injuria means harm caused with consent cannot be considered an injury. Harm caused with consent can be considered to be an injury. Harm caused and consent are irrelative terms. Consent is immaterial as far as harm is concerned. The maxim voluntary non-fit injuria, that is an act done voluntarily, is a harm caused with consent and cannot be considered an injury. A is the correct answer. The right of private defense under IPC is available for the protection of self and property, self, other humans, and of property, self and other humans, and only self. It is self, other humans, and of property. The term abet in general usage means assist and promote, help and perform, perform and complete, promote and perform. It is assist and promote, that is to commit abatement. Assist and promote. In a designer of check attracts criminal liability under Indian Contract Act, Negotiable Instruments Act, General Clauses Act, Indian Penal Code. It is under Negotiable Instrument Act under section 138 of IPC. When two or more persons agree to do or cause to be done an illegal act, it is called pursuance of common object, criminal conspiracy, common intention, abatement, and commission of crime. When two or more persons, it is criminal conspiracy. Under section 120A of IPC, the criteria for criminal conspiracy is that there should be at least two or more persons to do or cause to be done an illegal act. It's called criminal conspiracy. The number of persons required to constitute the offense of unlawful assembly as under the IPC are exactly 4, 3 or 5, 5 or more. It should be 5 or more. 2 or more, that is criminal conspiracy. 5 or more, that is unlawful assembly. The chapter of offences relating to elections was added in the IPC in the year 1920. This was done as the British India government introduced limited scope of participation for Indians in government elections. Both 1 and 2 are incorrect. Both 1 and 2 are correct. This should be the correct answer. The chapter of offences relating to election was added in the year 1920, and this was done because the British India government introduced limited scope of participation for Indians. Both 1 and 2 are correct. The crime of unlawfully damaging or destroying property by fire is called robbery, arson, burglary, deceit. It is arson. Unlawfully damaging or destroying property by fire is arson. Prosecution means a civil suit, an action in torts, institution of a suit, making of criminal charge before a judicial magistrate. It is making a criminal charge before a judicial magistrate. Which law commission dealt with offences related to religion and under section 295A? Which law commission dealt with offences related to religion under section 295A of IPC? It is the 5th law commission. All the offences with one exception relating to marriage under chapter 20 under the IPC deal with all the offences with relating to marriage are dealt under chapter 20 with only exception of any of these options. given below. That is marital rape, dowry death, dowry. These all are related to marriage. Infidelity is an exception to chapter 20 of the IPC. The Indian Penal Code 1860 was prepared by the first law commission chaired by Lord Macaulay. A person driving a car loses his control of the car and causes death of a pedestrian. He has committed death by rash and negligent act, murder, culpable homicide not amounting murder. It is death by rash and negligent act. It is not a murder because the intention for killing that person to cause death to the pedestrian was not in existence. A juvenile under the Juvenile Justice Act 2000 is one who has not completed 18th year of his or her life, 16th, 18th or 21st. Juvenile Justice Act 2000 provides that a person who has not completed 18th year of his or her life is a juvenile. Sexual intercourse with a girl below the age of how many years amounts to rape, even if it is done with the consent of the girl. It is 16 years. 16 years. Under Article 375 of IPC, it is provided that if sexual intercourse with a girl below the age of 16 years is done even with the consent of the girl, it amounts to rape because a girl below 16 years of age is not informed enough to give consent. Therefore, it is amounting to rape. Indian Penal Code 1860 is a substantive law, procedural law, remedial law, or none of the above. It is a substantive law. Fine non potest culpa prenis erit, a Latin maxim, means let the punishment be proportion to the crime. Unequal things ought not to be joined. The exception affirms the rule in contrary cases. Punishment may have an end. Crime is perpetual. This is the correct answer. Punishment may have an end. Crime is perpetual. Fine non potest culpa perennis erit. Culpa is crime. Perennis erit is perpetual. मतलब it is continuous. Which of the following is a landmark judgment with respect to abolition of bonded labor in India? Bandhua Mukti Morcha case, Olga Tellis case, Shah Banu case, Vodafone case. It is Bandhua Mukti Morcha case. The consent obtained in case of sexual intercourse by means of fear of death or hurt does not constitute rape. It is false. Consent obtained in case of sexual intercourse by means of fear of death or hurt constitute to rape under section 375 of IPC. Offense of theft can only be done against movable and immovable property. Movable property only, immovable property only, none of the above. Offense of theft, there should be some movement, so it is done only for movable property. Death caused by grave and sudden provocation is culpable homicide. Culpable homicide amounting to murder. Culpable homicide not amounting to murder, or murder. Death caused by grave and sudden provocation is culpable homicide not amounting to murder. Grave and sudden provocation is an exception given in exception to culpable homicide amounting to murder. It is an exception because of the absence of intention. Grave and sudden provocation There was no intention. Therefore, this amounts to culpable homicide not amounting to murder. The action of forcibly taking a person or persons, minor or adult, away against their will is called abduction, kidnapping, abscond. A and B. It is abduction. A person who helps someone else commit a crime is known as antagonist, principal, hinderer, accomplice. It is accomplice. A person who helps someone else commit a crime is known as accomplice. To depart secretly and hide oneself in legal terms means to escape, abscond, break out, run off. It is abscond. Culpable homicide means the crime of killing someone illegally with or without an intention to kill it. Lawful killing, which is classified as murder due to the evil intention of killing. The crime of killing someone illegally, necessarily without an intention to kill. The crime of killing someone illegally, necessarily with an intention to kill. It is murder. The crime of killing someone illegally or without an intention to kill is culpable homicide. A is the correct answer. Unlawful killing of a person by his friend, acquaintance would be termed as genocide. No, it would be culpable homicide amounting to murder. So the statement is not correct. It will be not termed as genocide. A hostile witness is unfavorable witness, adverse witness, a witness who was at the place of the incident when it happened, both A and B. A hostile witness is an unfavorable witness or an adverse witness, both A and B. When a person who committed a crime is to be prosecuted, the burden of proof lies upon the court, police, prosecution, or defense. It lies with the prosecution. The minimum number of persons required for a criminal conspiracy is 2 under section 120A of IPC. Homicide in legal terms means capital sentence, killing of a human by another human being. It is killing of a human being by another human being. In legal terms, the permanent dispossession of the sight of either eye would amount to grievous hurt. Permanent dispossession of the sight of either eye would amount to grievous hurt. The vital ingredients of a crime are knowledge, intention, and action, motive, intention, and knowledge, motive, mens rea, and actus rea. It should be motive, that is intention, mens rea, that is guilty mind, and actus reus means act, which is guilty act. Robbery becomes dacoity when the total number of people committing the same is at least 2, at least 5, at least 10, over 2 but less than 5. It is at least 5. Innuendo in legal terms is defamation, nuisance, trespass, battery. Innuendo in legal terms is defamation.